Hi everybody, and welcome to the welcome everybody to another session of ALMA-IHL Forum Book Launch Series. I'm Ihl Rosenzweig. I'm the chairman of ALMA, the Association for the Promotion of International Humanitarian Law, an Israeli located NGO, which is aimed for the promotion for the discussion and understanding and development of international humanitarian law. I'm very happy for you to join us to this another new session of our IHL book launch series. We've started at the beginning of this academic year, and it's going very, very well. And we've been having very good book introductions and then discussions. All of our previous sessions are available on our website as well on our YouTube channel. The event is live stream and recorded. Live stream on our Facebook channel and recorded on our live stream. The event is live stream and recorded on our YouTube channel. And what we are going to do is I'm going to ask Carolina, our event coordinator, to introduce the speaker for the event, and then we're going to start with the very, very interesting discussion of Anne's book. Please, Carolina.
Hi, everyone, and thank you for being here with us today. My name is Carolina Grimberg Golijov, and I'm ALMA's forum coordinator. And as Ido said, I'm going to introduce the speakers, and then we'll move forward with the presentation of the book. Anne Quintin is the head of the Advisory Service on International Humanitarian Law at the International Committee of the Red Cross. She joined the ICRC in 2008 and has since held various positions both at headquarters in Geneva and in the Washington, D.C. delegation. Before joining the ICRC, Dr. Quintin worked for the Geneva Academy of International Humanitarian Law and Human Rights and for the San Remo Institute. She has also held academic positions, including a visiting lecturer at the Perry School of International Affairs and at the Elliott School of International Affairs at George Washington University, and as a visiting scholar at the Asia Pacific Center for Military Law at the University of Melbourne. Anne is the co-author of How Does Law Protect in War and the related online database, alongside with Marcos Asoli, Antoine Bouvier, and Julia Grignon. Anne Quintin holds a PhD in law from the Faculty of Law at the University of Geneva, as well as a Bachelor of Arts in Politics, Philosophy, and Economics from the University of Kent, England, a master's degree from the Institut d'études politiques in Lille, France, and an LLM in International Humanitarian Law from the Geneva Academy of International Humanitarian Law and Human Rights. Aurel Sari, Dr. Aurel Sari is an associate professor of public international law and the director of the Exeter Center for International Law at the University of Exeter. His work focuses primarily on international conflict and security law and the law relating to military operations. He has published widely on the law of armed conflict, status of forces agreements, peace support operations, international human rights law, and the legal framework of European security and defense policy. His work has been funded by the British Academy and the Economy and Social Research Council. In addition to teaching law at the University of Exeter, Dr. Sari lectures regularly on international law and military operations in the UK and abroad. Elvina Pothelet is a legal advisor at the Diakonia IHL Center in Jerusalem. She previously worked for Diakonia's Mali desk, as well as for the ICRC, the Geneva Academy of International Humanitarian Law and Human Rights, and for Geneva Call, and collaborated with several academic, governmental, and human rights organizations. She was notably a visiting researcher at Harvard Law School and a legal advisor in the reserve of the French Army. Elvina holds a PhD in law from the University of Geneva, an LLM in International Humanitarian Law and Human Rights Law from the Geneva Academy, and a Master's in International Relations from Sciences Po Lille in France. So now we will move forward with the discussion.
Yes, we're going to start with Anne, who will introduce shortly her book, and then Aurel and Elvina will present their comments. And Anne, will respond to some of the comments, and at the end, we will open the session for a Q&A from the audience. So please, Anne, the floor is yours.
Thank you, Ido. Thank you, Carolina. So good evening, everyone. And to start, a big thank you to ALMA and to you, Ido, and you, Carolina, for the invitation and for the organization of this panel. And of course, thanks to Aurel and Elvina as well for taking the time to read the book and finding interesting things to say. Hopefully, about that you found some interesting things to say in it. And also I have to say that I feel very privileged because I can see in attendance that there are many names of friends, colleagues and former colleagues, friends from other continents, and it's really, really nice to see everyone. So thanks as well for to participants for taking what I'm sure are from your busy schedules to listen to this panel. So before I go into the introduction of the book, maybe what is a typical disclaimer as an ICRC lawyer, to say that what I'm going to say is on my personal capacity, and what I'm going to say today, but also what is in my book are actually my personal views and do not necessarily reflect the ICRC's views. So on this, I'm happy to say a few words about what I discussed in the book called The Nature of Ihl, which really focuses on the question of whether IHL is exclusively a restrictive regime, or whether it is both permissive and restrictive, meaning that the book asks whether IHL contains rules that can serve to authorize certain conducts during warfare, or whether it is composed only of prohibition and prescriptions. So I'll try to take some of the main findings out of the book for a few minutes, and then I'm very happy to go into more details based on the Q&As. And before going into some of the core conclusion, I wanted to stress a methodological point in introduction, because that's one that I kind of struggled with at the beginning of my research, which is the fact that I realized that in the few writings that existed on the topic of the nature of IHL and whether it's restrictive or permissive, I felt that the authors that had written on the topic approached that question from what I called a teleological perspective, meaning that it was really considered that IHL had to be one way or the other because of a specific end goal. That was, for instance, some would say that IHL can only be restrictive because otherwise it could not be a truly humanitarian legal regime. But I also heard from some audiences that IHL had to permit certain things because first it regulates them, but also IHL was the only way to fill in gaps in international or domestic law. And this is something that I also heard from military lawyers. For instance, I heard that IHL has to authorize because otherwise, if IHL it did not authorize internment or targeting, for instance, the consequences would be that such conducts would actually be unlawful, which of course was considered as unrealistic and militarily too constraining and should be avoided. So that led me to the realization that there's a confusion in the terms, I think, in the sense that the confusion is in itself linked to the fact that such terms are rarely defined in existing literature. So I found the use of different terms interchangeably, for instance, authority, permission, legal basis, power, license, rights. You can find all of that in existing literature. And most of the time they are used because we are aiming at reaching one conclusion or reaching one consequence, or saying IHL has to be this way or has to be the other way. So on that basis, I really wanted to approach that topic with or without actually any preconceived idea. So for me, the way of doing that was to start not with IHL itself, but to start with legal theory, and in particular with deontic logic. And I won't go too much into the detail at this point because that's probably not the most interesting part, except for legal theory geeks in this audience. But basically, what I tried to do was asking myself the question of, what are we looking for when we ask the question of whether IHL permits or authorizes something? So I looked at theories of norms and the deontic modes of norm. So I used the writings of renowned authors like George von Wright, and I came to the conclusion that basically there are two concepts within the notion of permission. The first one is that you have some permissions that derive from the absence of norm. And in that case, the permission is implicit from the absence of prohibition. This is what von Wright has called weak permission. And you also find terms such as non-norm governed permission. And on the other hand, you have permissions that also derive from existing rules, meaning that there's a norm that exists that explicitly authorizes a conduct. And so those are strong permissions. And you also find in literature that they can be called norm-permitted permission. And so from that dichotomy, what I try to do is to determine whether IHL contains strong permissions. So I wanted to go this way for a couple of reasons. The first one is because of that dichotomy, the statement behavior X is permitted is actually ambiguous. It can mean that the behavior in question is not prohibited by any norm, and in that case, the character of being permitted is as a purely negative signification. But if you say behavior X is permitted, it may also refer to the existence of a valid enabling norm explicitly permitting the conduct. So when you hear from states or others that they have the position that a conduct is permitted, it is ambiguous. So we need to go into the detail of what this means, whether it's an absence of prohibition or whether there's something that actually empowers them to act. And of course, one of the other obvious reasons to look into that dichotomy was for me the requirement under human rights law that certain conducts have a legal basis somewhere before they can be resorted to. So most of the time, and I'll come back to that, that requirement implies the existence of a permissive rule or of what is called a legal basis under human rights law, which is not something that exists under IHL as a term. So that's where I started, and so on that basis, my main conclusion was that IHL actually is a restrictive regime. So that was the first point. And for me, that was clear from the historical development of IHL, looking at the travaux préparatoires of several diplomatic conferences, ranging from the Brussels conference to the Hague peace conferences. It was quite clear that the objective of the drafters was to limit the unlimited powers of states. So this is something that kind of, at that point, I realized that I was actually learning a lot myself because as many, I think I was starting from the assumption that, Hague laws would be more permissive and Geneva law would be more restrictive. But actually, I found that in my research that it's not really the way things work, and it's rather a question of what the drafters had in mind. And in that basis, I found so many statements with the state representatives of all those conferences were really insisting on the willingness to limit the powers of states with the IHL, I mean, not called IHL at that time, but the laws of war instruments. But at the same time, working evolving in my research, I also reached the conclusion that it is impossible to say that IHL is entirely restrictive. You do find some permissive rules, and permissive in the strong sense, in my opinion. So I'll give a few more details and take a couple of examples at this point. So going into going into those examples, the first conclusion in practice for me is that the strong permissions that exist in IHL are mainly found in the law of international armed conflict, and I guess that won't come as a surprise to anyone here. And the obvious examples are in internment for POWs. You can say that Article 21 of GC3 is a strong permission for the detaining power to intern prisoners of war. For civilian internees, you find both the set of rules, Articles 41, 42, 43 in GC4 for the own territory of the belligerent state, and Article 78 for occupied territory, which, in my opinion, are strong permissions as well. And this actually is in line with other provisions within GC4, for instance, Article 38, which speaks of the special measures authorized by GC4, meaning that there are measures authorized somewhere. And there's a direct reference to Article 41, for instance. So, but again, these were almost obvious conclusions, and things got less easy when looking at the law of non-international armed conflict. And here, the question was, how can IHL grant authority or strong permissions to states without granting the same authority to the non-state armed group party to the armed conflict? And of course, when you read the Travaux Préparatoires, this is a recurring question on how to not empower the non-state party to a NIAC. And I think this is one of the reasons why you do not find strong permissions for internment in NIAC, in my opinion. And looking at treaty law, you don't find anything in Common Article 3 or in AP2. Internment is only envisaged as a matter of fact and not as a legal entitlement. And here, I guess, like, I'm coming into the more debatable parts of the book, or at least the parts that I'm sure my co-panelists may come back to. But I also argue that customary law does not provide a strong permission to intern in NIAC either. I reached that conclusion without going into too much detail at this point, but because first, I found that several states actually acknowledge the fact that IHL does not contain any measure permitting internment in NIAC. So you find that in a few military manuals, but also the analysis of the practice of states involved in a NIAC. And in that case, I looked at both practice on a belligerent's own territory and at the practice of states involved in what we call extraterritorial NIACs. So on the territory of other states, and very often the states parties to a NIAC, they rely on other sources than IHL to justify internment. So in internal NIAC, in between inverted commas, you would find that the source would be from domestic legislations, and very often actually counterterrorism measures that allow administrative detention for longer periods than what is customary in peacetime. Or you also find in extraterritorial NIACs that states would rely on status of force agreements, host state agreements, SOPs, or even UN Security Council resolutions. So this is, and that was for me, I reached the conclusion that this was the large majority. So even if there are few instances, I have to admit, where states have said officially, and including in multilateral fora, that IHL provides, in their opinion, an inherent power to intern in NIAC, I think this is counterbalanced by the huge amount of practice where they actually do not really rely on IHL directly. So that was the first conclusion in internment. The second conclusion is to say that having said this, so that strong permissions are mainly in IAC and not in NIAC, actually, when I moved to targeting, I am arguing that there are strong permissions that you can find in non-international armed conflict, actually. So, and this is, so to go into the short, again, trying to be short on what targeting rules say. For me, in IAC, the combatant privilege and the right for combatants to directly participate in hostilities, they are the basis to say there's a strong permission to target members of the enemy armed forces. Here again, I don't think this is very surprising. But in parallel, I also find, and again, that's going back to the definition of what a strong permission is. I argue that in both international armed conflict and non-international armed conflict, there is a strong permission under IHL to target individual civilians who DPH, because DPH is an exception to a prohibition. So there's a deliberate willingness to stop the prohibition from targeting civilians and to add another layer to that, which is the basic definition of what a strong permission is. And so similarly, I reached the conclusion that a strong permission also exists in NIAC to target members of an organized non-state armed group. So basically those members within the non-state party to the NIAC that have the continuous combat function, to use ICRC terms. And what is interesting for these conclusions is that they have no explicit addresses. So for me, that I took that as the fact that, you know, the rules imply that certain persons lose their protection and may be targeted, but the rules don't say by whom they may be targeted. So because of that, I conclude that they apply to all belligerents, just like the other rules. So meaning that that permission also applies to the non-state party to the conflict. But conversely, to finish on targeting, I would say that there is no strong permission that you can find authorizing a non-state armed group party to the NIAC to target members of the armed forces of the adverse state. So that was for internment and targeting, and maybe to conclude briefly. Another conclusion that I reached in my book is that is the relationship between IHL and international human rights law, and the link between the strong permission notion under IHL. Or what I try to find whether strong permissions exist under IHL and whether that can be equated with legal basis in the sense of human rights law. And so here again, two cases emerged. The first one in relation to the deprivation of liberty. So meaning that I looked at the right to liberty under human rights law and the strong permission or absence of strong permission that I found on internment under IHL. And so here, I would say that when the strong permission under IHL gives the authorization and provides the grounds and procedural guarantees according to which the deprivation of liberty shall be carried, then I would say that the IHL permission will amount to the required legal basis under human rights law. So for me, that means that in IAC, GC3, GC4 are sufficient legal basis under for the purposes of human rights law. By contrast, I also looked at, of course, the absence of strong permission in non-international armed conflict on internment, and for me, clearly that means that IHL cannot be used as a legal basis in the sense again of human rights law. And finally, I also found that that analysis differs when we move to the question of the right to life, because here the obligation that the right to life be protected by law creates the obligation to have in place and to comply with a legal framework that constrains the use of lethal force. So that's where there's a difference with the right to liberty, where there's a different kind of obligation under human rights law, which requires the existence of a legal basis. Here, when we talk about the right to life, it doesn't mean that we need to have a legal basis to kill someone. We need to have a legal framework that regulates or constrains the use of force. And so I come to the conclusion that IHL actually, in both IAC and NIAC, brings and provides that legal framework that constrains the use of force during armed conflict and complies with the requirements of human rights law for those reasons. So I'll stop here because I see that I'm already going over time. So those were the main conclusions. I go through other different aspects, which I'm very happy to discuss in conclusion. But again, I'll stop here and thank again my co-panelists and ALMA for the chance to be here. And I'm very much looking forward to the discussion.
Thank you, Anne. Personally, I would like to hear you talk more and more about the right to life aspect of IHL. I think we should move to the first commentator, and that's Aurel.
Thank you very much. So good evening, everyone, and or good afternoon, depending on where you are. Thank you very much to ALMA and to Ido and Carolina for inviting me to this book launch. I have to start with a confession. When I heard that Anne's book is coming out, I thought to myself, "Ooh, this sounds really, really interesting. I need to get a copy of it when it is published." So I'm really grateful to our hosts for inviting me today to read the book and also to offer some of my thoughts and impressions on its content. So in a nutshell, I think this is a wonderful book. I very much enjoyed reading it, both in terms of reading. It's a gripping book. It's really well written, but also I very much found myself nodding along the way. There are a couple of points, perhaps, I think, where we can have a debate, and Anne mentioned detention as one of these areas, and I'll come back to that. But it is very much warmly recommended, so please do go out and read it for yourself. But let me take a few moments to explain why I think it is a very significant and useful addition to the literature. So as far as the subject matter is concerned, what Anne's book does, it grapples with a subject that I think many of us have been thinking about, either deliberately, explicitly, or perhaps sort of at the back of our mind, which is the question of whether the law of armed conflict is a permissive or a restrictive legal regime. I think the reason why many of us have come across that question is that when you look at the rules on law of armed conflict, although they are framed as prohibitions, most of them are, they seem to go hand in hand with permissions, or perhaps there is a permissive dimension to some of these rules. You don't really have to go very far in the law of armed conflict in the body of the various treaties. For instance, if you take Article 35 of Additional Protocol 1, which refers to the rights of the parties to a conflict to choose the means and methods of warfare, and says that this is not unlimited. On the one hand, it is clear from that provision that there is a prohibition. Certain means and methods of warfare are off limits. But of course, not all of them are. So that's where you possibly see that permissive dimension, that some types of methods and means of warfare are perhaps not just not permitted, but perhaps even permissible. But then you also find that language of rights. So the parties to the conflict have a right to choose some means and methods of warfare. So we find quite a number of provisions in the treaties where you see that prohibitive, but at the same time also potentially permissive streak in the law of armed conflict. So some have always wondered, I think, whether the law of armed conflict isn't just about restrictions, but also perhaps facilitates acts of hostility. Is the law of armed conflict complicit in warfare? Is there a darker side, essentially, to our virtue? So I think this is a really important and also very serious question, because it goes partly to our understanding of the law of armed conflict, but also perhaps to our self-perception as scholars and practitioners of IHL. What is this body of rules that we're actually working on? So perhaps for that reason, it's not surprising that many of us, again, scholars and practitioners, have formed a view as to the nature of the law of armed conflict, about its permissive or prohibitive nature. But I think what we have been missing so far in this debate is a sustained and in-depth investigation of exactly this question. So I think Anne has done us a huge service as a community, again, of scholars and practitioners, by taking the courage to confront a very difficult, very fundamental, very challenging question head on, and to produce a detailed study that I think will inform the discussion for years to come. Now, in addition to tackling that subject head on, I think for me, certainly one of the main merits of Anne's work is her approach and how she does it. And she describes some of that in some of her approach in some detail, so I don't want to replicate. But again, let me just point out what I think are the key merits of her approach. And I agree entirely with Professor Sassoli, who wrote the foreword to Anne's book. And in that foreword, and I'm quoting him here, he says that good law books deal with a problem of relevance, but they place the solution into a larger theoretical framework. Anne's book obviously tackles a question of practical relevance. As she has pointed out, one of the main reasons why we might be interested in this question of whether the law of armed conflict is permissive or prohibitive is because of the impact of human rights law. If the law of armed conflict does not contain positive authorities, strong permissions, as she puts it, then potentially human rights law prohibitions will simply take over. So it's almost like, I don't want to say a fight for life, but ultimately it's a fight for the relevance of the law of armed conflict to decide this question of whether it is a permissive or a restrictive legal regime. So clearly the question is one of relevance. But Anne's book places that question into the broader theoretical framework that Professor Sassoli mentions. And I think that is one of the major contributions that she makes to the debate. And as she has explained, she distinguishes between weak permissions and strong permissions. Much of the debate around permissions, around authorities, has really failed to grapple with what we mean by this. So I think Anne's book offers us, and her framework offers us an opportunity to actually develop a common understanding and a shared language of what we actually mean when we ask the question, is LOAC permissive or is it prohibitive? So what I found really interesting and very compelling is her idea of strong permissions, that this is ultimately what we are looking for, strong permissions. And there are two types of strong permissions, as Anne explained, and again, I don't want to repeat what she said, but her idea that strong permissions are not just explicit in the sense that rules in the law provide for a state or for another actor to do a certain activity and explicitly say so, but they can also be implicit. They can be implicit in a prohibition. And she cites Hans Kelsen, which is always a good thing to do, as an example of such an implicit strong permission. Hans Kelsen suggests that if you take the rule which prohibits the killing of another human being, that rule is subject to a limitation or an exception for self-defense. So it is prohibited to kill other human beings except in self-defense. And what Kelsen says is precisely that this exception, this limitation to the prohibition, is essentially a strong permission. Why? Because it reflects the deliberate choice of the lawmaker, of the legislator, to exempt that particular activity, killing in self-defense, from the scope of the prohibition, and therefore indirectly or implicitly turns that exception to the prohibition into a permission. Now, that approach, I think, is critical when we are looking at the various rules on the law of armed conflict, because if we go along with this understanding of what strong permissions are, then all of a sudden we can look at a large number of the rules in the law of armed conflict in the various treaties, but also in the custom, and actually find ourselves looking at rules which contain indirect or implicit strong permissions. So I think Anne's conclusions, again, that she set out as to where we find these permissions are very compelling. She mentioned in international armed conflict, you will find strong permissions for detention, in particular Article 21 of Geneva Convention 3, and then you find the corresponding provisions in Geneva Convention number 4, as far as civilians are concerned. But also for targeting rules, we find combatant privilege, as it is reflected in Article 43 of Additional Protocol 1, again, implicitly contains a strong permission to use lethal force against enemy combatants. And also we have the rules on DPH, which yet again implicitly imply or include a strong permission to use lethal force against civilians for such time as they are directly participating in hostilities, both of course in an international as well as in a non-international armed conflict. So I think from the theoretical approach that she takes, based on a very extensive analysis of state practice as well as a very sharp reading of the relevant treaties, I think her conclusions and findings are sound. Don't take my words, go get the book and read it. But I would think that these conclusions are not particularly controversial. And again, Anne makes an excellent case for them. I think where there is room for debate, because I think there is still a little bit of room for debate, is when we come to the general conclusion that Anne draws from this, but also I think to her points on detention in NIAC as well as proportionality. So first of all, the general overall conclusion of her work is that LOAC-IHL is primarily restrictive in nature. And as Anne said, a lot of the literature on the nature of LOAC seems to be sort of very binary in thinking of LOAC must be either restrictive or it must be permissive in its approach. Of course, Anne avoids that by saying that LOAC is primarily restrictive. And I think that's a very fitting description. If we look at the tone and the number of the rules, we'll find that most of the rules are indeed framed in a restrictive sense. And the vast majority of the rules takes this restrictive approach. So I think to say LOAC is primarily restrictive correctly and appropriately reflects the general tenor and the general tone of the law of armed conflict. But where I would sound a little bit of caution and perhaps say, well, we have to put that conclusion into context, is that we shouldn't take that conclusion to mean that the permissive dimension of the law of armed conflict is somehow secondary, that it is not quite important, that it is an afterthought or maybe just a sideshow to the law of armed conflict. And the reason why I say that is, although perhaps the permissions are relatively few in number, nonetheless, if you look at what they do, essentially, they are the basis for status-based targeting in an international as well as non-international armed conflict, and of course, then also for detention, as far as IAC is concerned. These rules are these permissions are absolutely central to what the law of armed conflict is. And don't get me wrong, I'm not suggesting that Anne somehow misunderstands this or misrepresents this, but I think it's important to keep in mind that when we say, yes, LOAC is primarily restrictive, not to lose sight of the fact that these perhaps secondary permissive dimension that Anne describes is nonetheless central to what the law of armed conflict is ultimately all about, in the sense that this is ultimately what distinguishes it from other similar areas of the law, including international human rights law. So let me say a few words on detention. Anne suggests that the law of armed conflict does not contain any strong permissions for interning persons in a NIAC, and I'm not entirely convinced that that is the case. Of course, when you look at IAC, International Armed Conflict, we have Article 21 of Geneva Convention 3, and we also have the list of persons who are entitled to POW status under Article 4 of GC3, and they provide essentially a concrete manifestation of the authority to intern. So in a way, perhaps the conclusion that there is a permissive authority to detain, intern in IAC isn't perhaps such a big surprise, because we have an explicit rule which says so. Of course, in a NIAC, we don't have a comparable single rule, and that's part of the problem. So we either have to look for such a rule somewhere implicitly in the text, or perhaps we have to look under custom. But I do think that there are other manifestations of that permission to intern in a NIAC, perhaps not in a single rule, but I think there are there. For me, the reason for that is, if we go back to the very nature of a NIAC, we have to acknowledge that NIACs are not internal disturbances, they're not just tensions, they're not just riots, they are armed conflicts. In fact, if you look at the language of Additional Protocol 2, it refers to sustained and concerted military operations. It talks about combat, about armed forces, organized armed groups, conduct of hostilities, and attacks. these are not just factual terms. They are technical terms, terms of art, and they have normative implications. If you take the word attack, for instance, attack is mentioned in Additional Protocol 2 in Article 13, and as the ICRC commentary informs us, the term has the same meaning in a NIAC as it has in an IAC under Article 49 of Additional Protocol 1. So an attack refers to acts of violence against the adversary, whether in offense or defense. Okay, why is that important? Well, I think it's hugely important because what that means is that treaty law states, the law of NIAC accepts that there is a justification for acts of violence, and that justification can only be military necessity and the military purpose that the violence serves. Otherwise, any destruction would be wanton, or any killing would presumably be unlawful or unnecessary, and perhaps even lead to superfluous suffering. If you look at other parts of the law in NIAC, for example, you find reference to military objectives. Again, I feel that this is very, very significant, because once you accept that the notion, the very idea of a military objective exists in a NIAC, it means that treaty law accepts that there must be a military advantage. So there is a military advantage which serves as a justification for the destruction, capture, or neutralization of objects. Now, all of that, to my mind, simply reflects the simple fact, the simple normative reality that NIACs are armed conflicts. And that, to my mind, has certain consequences. That is exactly, I think, what lies at the heart of Anne's argument about the permissibility of status-based targeting in a NIAC. She refers to, in her book, to membership in an organized armed group, as well as the distinction that Additional Protocol 2 draws between civilians versus persons, in other words, civilians and non-civilians, as the kind of anchors, the concrete manifestations of the underlying reality of armed conflict in NIAC, that there must be status-based targeting. Of course, there's more than this, because state practice actually demonstrates quite conclusively that states themselves accept that there is status-based targeting in an IAC, but in terms of the actual treaty provision, actual treaty text, it is that notion, that concept of membership in an organized armed group, plus the distinction between civilians and other persons, non-civilians, which is your textual anchor for that. And that got me thinking, well, that's really interesting. So if we're happy to accept that for the purposes of status-based targeting, these textual anchors are sufficient to count as a strong permission, why do we hesitate to accept exactly those same words and those same concepts as an equally sufficiently strong permission for the purposes to detain? And here again, I would refer back to the nature of an IAC as an armed conflict. It's not by analogy to an international armed conflict that we might want to, or states might want to detain and intern individuals who are members of an organized armed group in an IAC, but it is because of the very independent logic of an IAC as an armed conflict, the independent operation of military necessity, as reflected again in the notion of military advantage, military objectives, attack, and all of these concepts that we find strewn around Additional Protocol 2, as well as, of course, customary international law. They all reflect the underlying reality. So perhaps I can put that as a question to Anne, or one of the questions that I would like to raise. If the text is good enough for status-based targeting, then why shouldn't it also be good enough for status-based detention in NIAC? And again, perhaps we can pick this up in the Q&A. Also, and I don't want to get too much ahead of the Q&A, but on proportionality, Anne's conclusion is that there is no strong permission for causing incidental harm to civilians and civilian objects. In other words, that the proportionality rule does not give rise to a strong permission. And I was again struck because the way the prohibition is framed, essentially as prohibiting harm that is excessive in relation to the military advantage, to my mind, isn't really that much different from some of the other rules that she accepted are strong permissions. So again, perhaps that is something that we can return to in the Q&A. But overall, I thoroughly enjoyed reading the book. It's like any good book, it provokes thought and discussion. And I very much congratulate you on this magnificent achievement.
Thank you, Aurel. And now, without any delay, we move forward to Elvina.
Thank you, Ido. And thank you, Alma, for inviting me to this book launch. It's really a privilege to be sitting on this panel with Anne and Aurel, who are two practitioners and scholars that I respect really much, immensely. So I'm really, really glad and honored to be here. And of course, I would like to start by warmly congratulating Anne. In fact, I should really thank her for a truly eye-opening take on the nature of IHL. And for what I found is really a very rich, clear, really clear and compelling analysis. I'll come back to this. There is, I think, absolutely no doubt that the book makes a very significant contribution to the literature. Aurel mentioned why. And it addresses such fundamental questions that I am sure it will be of interest to all IHL scholars and practitioners. This is for sure. Just before I start, I should clarify that I'm speaking in my personal capacity as well. So the ideas that I will be sharing do not necessarily reflect those of the Diakonia IHL Center. So the question of whether IHL is a source of permission in war, or strong permission, I would say, is relevant for several reasons. Anne mentioned an important legal reason. This is because with the development of human rights law, states must now provide a legal basis for certain conducts in armed conflicts. But I think the question that Anne addresses is also part of an important soul-searching exercise that we IHL lawyers need to engage in. And Aurel mentioned this earlier, so I fully share the sentiment. I think it's fair to say that in the past few years, IHL has been suffering from an identity crisis. We often hear from military lawyers, not all, but some of them, that IHL can help them justify their conducts that are not normally tolerated. And on the other hand, we hear humanitarian and human rights practitioners push back and insisting that IHL is only there to protect and restrict acts of war. But when I interact with these humanitarian practitioners, I feel sometimes that they too are even starting to doubt about the truly protective nature of IHL. Sometimes I feel a reluctance almost to invoke IHL for fear that it would lead to a less protective outcome. So I feel that the discourse around IHL being permissive is slowly spreading. There is discomfort, or at least doubts, around what IHL actually does. And so Anne's studies is really important to offer clarity in this respect and make sure that IHL serves its intended purpose. The object of the study is IHL, but one of the strengths of the book is that IHL is analyzed as part of the broader international legal environment. So Anne notes that IHL is a branch of public international law, and she engages with an old debate concerning the nature of public international law generally. She also integrates human rights law in her analysis as she explores the significance of having or not a strong authorizations in IHL for the purpose of complying with human rights law. So I think the systemic approach really enriches the analysis. And to some extent, it allows Anne to nuance her findings. So she makes clear that it's not because IHL does not grant strong permission that a conduct is necessarily unlawful under human rights law or unlawful under international law in general. So as Anne mentioned, the book proceeds into three main steps. First, it clarifies the nature of IHL. Second, it asks whether IHL provides an authority to intern. And third, whether it provides an authority to target. So I will make a few comments and raise a few questions following this order, because it just flows naturally. So part one, to me, has been really the most enlightening, and yet I'm not a legal theorist geek, as Anne calls them, but it provides such a neat analytical framework. It is indeed superbly written. You manage to capture in only a few words really complex ideas, and I really want to insist on this because that's really an exceptional ability that you have to explain things so clearly and so eloquently. I was really in awe. So this first part helped me put the right term on so many ideas. It helped me connect some of my intuitions, I guess, to existing theories and principles. So I really have to thank you for this. There are many important ideas in this first part that will stay with me. Your distinction between weak and strong permissions, of course, the idea that it's not because IHL regulates a certain course of action that it provides a strong permission for it. I also found your historical account of the separation between use ad bellum and use in bello really valuable. We IHL lawyers, I feel we rely heavily on this separation, but we don't really always necessarily know the history of this separation. So I thought that was very useful. And part one also helped me refine my understanding of important principles like the Lotus Principle. What you reveal there, that this principle, or whether I should say the principle of residual freedom, actually may not apply beyond a state's border. I mean, that sounds to me like a pretty big caveat. Also your point on the principle of military necessity not being a source of strong permission, like we've just heard from Aurel, but rather only imposing additional limits on states' natural freedom. And I could go on and on. I mean, there are various aspects of part one that were really enlightening. So it was a really rich and helpful reading. Now, after reading part one, I still had a question at the back of my mind, which is, even if we find no strong permission for a certain conduct within IHL, does it mean that there is no permission for this conduct at all? So couldn't the permission come not from IHL, but from elsewhere? The reason I had this question is because before I started reading the book, I had a rough hypothesis in my mind, and it was that IHL itself may not be permissive, but it may nonetheless be based on a permissive assumption, and that authorizations could indeed come from elsewhere. I didn't know where, but from elsewhere, but not from IHL treaties or even not from IHL custom, but I didn't know, from somewhere. So you, of course, addressed these questions in part one, but I wonder whether there isn't still room for an argument there, so that there could be authorizations in war outside the realm of IHL. So this will give me the opportunity to try and summarize your reasoning, I guess, because you went quite quickly through it earlier during your presentation, and yet that was really such an important part of the book to me because it underlies your entire argument. So if I understood correctly, and I hope you'll correct me during the Q&A if I got anything wrong. So you explained that IHL has been developed based on the assumption of natural unlimited state freedom. States are in principle free to act per the principle of sovereignty, and IHL is a body of law that restricts the natural freedom of states. As a consequence, IHL is made mostly of obligations and restrictions and weak permissions, but you specify that it may contain a few strong permissions in individual rules. So normally a restrictive body of law with exceptions. By the way, this part is really convincing and helpful, I think, and I was referring earlier to IHL lawyers' identity crisis. But when I read this finding of yours, I kind of had a sigh of relief. You know, I was like, yes, okay, that sounds like a really reasonable interpretation. IHL is protective, true, but there are some exceptions. So I think that it's the kind of proposals that can reconcile, you know, both sides of the spectrum. Anyway, so you open the door for strong permissions in IHL rules, in certain IHL rules, and then you go through other possible sources of strong permissions. So you go through the Lotus Principle, the principle of military necessity, the Martin's Clause, and you conclude that strong permissions cannot come from any of these principles or sources, right? But I guess I'm still left wondering about the starting point, which is states' natural freedom to act, as you call it, or like this underlying permissive assumption. And I wonder about its positive content. I wonder whether there isn't still room for states to find strong permissions there. So I guess what I'm asking even if we don't find strong permissions within IHL, is it really the end of the story? Or should we explore the positive content of this natural freedom? So of course, I realize this goes beyond the scope of your study, which focuses only on IHL. So it's more a kind of like for further research question. And I definitely do like the legal theory background there, but just thought I would flag this in case you want to clarify. Okay, so now I promise I will stick to more concrete questions. So moving on to part 1, on whether IHL provides an authority to intern in armed conflict. So this is where you look at specific rules of IHL. As we explained earlier, you find that IHL provides a strong permission to intern POWs, as well as a strong permission to intern protected civilians in IAC. But you add an important caveat to that, the fact that IHL permission can disappear. And I picked up in particular on what you say about prolonged occupations, which of course, as you can imagine, is of interest to us at Diakonia in Jerusalem. You explained that in situations of prolonged occupation, IHL, and in particular Article 78 of the 4th Geneva Convention, can no longer provide a permission to intern civilians who pose a security threat. So I guess this would mean that Palestinians currently held by Israel under that basis are being unlawfully interned. So that's an example of an important argument with practical relevance, I think. You also have an interesting idea, which is that if the detaining power does not comply with IHL rules concerning the treatment of detainees, then this would also invalidate the permission to intern in the first place. So that kind of contradicted my intuition, which was the opposite, that rules concerning the lawfulness of the detention to intern are clearly separate from rules on internment. So that I thought was very interesting. And then I wondered whether you thought of limits to that. So where the limit would be. Would any violation of any treatment rule invalidate the permission to intern? Where do you draw the line? And I guess also the logical conclusion of your argument would be that a state party to an IAC that interns protected civilians, if that belligerent violates, interns those persons in violation of the standards of food or else, for instance, this belligerent could be prosecuted for the grave breach of unlawful confinement, right? Because the internment would no longer be legal. I mean, the legal basis for the internment would no longer exist. So I just wanted to check if that's in line with your argument. Now concerning still internment, but in NIAC. So you find no strong permission for states to intern members of enemy armed groups, neither under conventional nor under customary IHL. But at the same time, later in part 3, you find a strong permission for states to target those same individuals. These two conclusions open the door to the lesser evil argument, which is the idea that if a belligerent is allowed to kill someone, then for sure it must be allowed to detain, which is the less harmful option. You reject this argument, but even after reading this part of your book, it still sounds like a strong argument to me. You have an interesting rebuttal, like you talk about the personal and temporal scope of the permission to target and to intern. I don't want to get into that now because I don't have the time, but as I wrote to you, like I'm not yet convinced. And so I guess my question to you now is, what is your main argument against the lesser evil arguments, basically, because I'm still to be convinced. Now moving on to part 3 on the authority to target individuals in armed conflict. So as you noted earlier, you find that in IHL provides a strong permission to target combatants, which sounds like a perfectly reasonable conclusion. But if I understood correctly, the gist of your argument rests on combatant privilege. So the fact that combatants have the right to participate in hostilities. This is the main source of permission for states to target combatants, according to you, I think. But so my question is, if the strong permission to target does not really belong to the state itself, but to its soldiers, through their combatant privilege. This leads to a question: what happens when states delegate targeting operations not to their soldiers, but to non-combatants? So I'm thinking of mercenaries, for instance. Mercenaries usually are not integrated into the armed forces, so they're civilians, and they do not have combatant privilege. So in this case, where would the permission to target for the states come from? Frankly, I would be perfectly comfortable saying that in this case, IHL simply does not provide the state with a strong permission to target. But I wonder what are your thoughts? And by the way, the same question would arise if the state uses or does targeting through autonomous weapons. Where would the permission to target come from? Because clearly autonomous weapons do not have combatant privilege, right? And a final point concerning targeting in NIAC now. So you find a strong permission to target civilians who are directly participating in hostilities, and a strong permission to target members of armed groups. However, you find no strong permission for armed groups to target state soldiers. So this finding was a bit disturbing to me. Of course, I understand the argument that states did not want to provide such a power to armed groups. I fully understand this, but I don't know whether we should just stop there. And I was surprised that you only dedicate one paragraph to this. So I just wanted to hear more from you on this. First of all, this finding raises the question of the principle of equality of belligerence, of course. IHL would then provide a strong permission to target only for one of the belligerent, the state. The state would be allowed to target its enemy, but not to the other. The armed group would not be allowed to target state soldiers. And you do refer to this principle of equality of belligerence in relation to internment. You say that there can be no strong permission to intern for states because they would not want armed groups to have the same power. But yet you don't discuss the principle of equality of belligerence when you conclude that states are permitted to target armed groups, but not the opposite. So I just wanted to have your views on this. And relatedly, I guess I'm concerned that this conclusion would jeopardize armed groups' incentive to comply with IHL. Why would they comply with IHL if this body of law strongly authorizes their enemy to shoot them, but not the opposite? And also, I think the other reason why I felt a bit uncomfortable with this finding is that you find no strong permission for armed groups to target state soldiers, but you find a strong permission for them to target civilians who are directly participating in hostilities. And so that creates, I mean, it's hard to justify, right? So again, if we have time, I would love to hear more on this. And I'm running out of time, so just by way of conclusion, maybe I wanted to share a final thought concerning the addresses of authorizations under IHL. Because when I was going through the book, there was one question that would regularly pop up at the back of my mind, which is, okay, even if IHL provides a strong authorization to intern or to target, who benefits from this authorization? You mentioned this just earlier today in relation to conduct of hostilities rules, because they are not actually addressed to anyone, indeed. They're framed in the passive form. So I guess, of course, the authorization would be granted to the states. It would be granted to the non-state party to the conflict in some cases, according to you. But another relevant actor in armed conflicts are civilians. In many conflicts, you find civilians using force. So can they too invoke IHL as an authority for their use of force? I referred earlier to mercenaries, but I'm actually thinking now of UN peacekeepers. Since in most contexts, UN peacekeeping missions do not qualify as a party to the surrounding conflict. Their activity just does not meet these thresholds. So they are civilians. The UN mission is a civilian entity. Peacekeepers are individual peacekeepers or civilians. And it seems that there is a practice at the UN consisting of applying the IHL principle of distinction when peacekeepers use force, notably for the purpose of protecting civilians. So again, even if the UN mission is not a belligerent in the conflict, in UN documents, you find this reference to the UN principle of, to the IHL principle of distinction. So I guess if the principle of distinction is invoked to make sure that civilians are not targeted, this is all good, of course, as far as I'm concerned. Now, if the principle of distinction is used by the UN, who is a civilian in the conflict, as an authority to use force against armed groups, to use force against legitimate targets, there we have a problem. And so I guess what I just wanted to flag is that I think we have to be very clear that even if IHL grants certain authorizations, this can only be to belligerents and clearly not to civilian operating in the context of an armed conflict. Okay, so I'll stop here. I really look forward to hearing more from you, Anne. And again, huge congratulations on a very impressive piece of work.
Thank you, Elvina. Now we go back to Anne for hopefully a short reply to some of the main points, because we do have some questions lining up and we do want to have some time for Q&A. So Anne, the floor is yours.
Okay, so well, first, thanks a lot to both of you, Aurel and Elvina. That was really fascinating to hear, and so maybe the first question is actually to you, Ido. How much time do I have? Because those are like complex questions, and I would love to go into all of them. But how much time do you give me to pick a couple?
Let's limit it to 10 minutes.
Okay. So I'll try to do that, and please stop me if I'm being too long. So maybe as a first overarching point, I really, the two of you really put your fingers on things that are not that I'm uncomfortable with, but with which I guess I struggled during the research, and because a lot of those questions are actually, they were almost like introspective questions for me, to be honest, in the sense that I was always torn between several aspects. On the one hand, I had the willingness to reach a result that would remain in line with what I consider as the humanitarian spirit of IHL. So I really wanted to avoid a conclusion that says, well, it's super easy to kill people, or it's easier to kill rather than detain. So I did struggle with that, and you put your finger on that, the two of you. But I also at the same time really wanted to come to a conclusion that was realistic, and I guess even more importantly, I wanted to avoid the theological approach that I mentioned at the beginning of my presentation. So I also wanted to try to avoid trying to fit IHL within my own preconceived ideas. So that's why I worked with on the framework and tried to have that that methodology at first, and then take any aspect of IHL and put it with through the framework. So I guess like this leads me to take a couple of your questions. So to start with what you were saying, Aurel, on detention and the fact that you could, if you come to the conclusion that status-based or rather membership-based targeting is a strong permission, why not membership-based internment in NIAC? And I guess my main answer would be to say, at least for targeting, I don't think it's just a question of the existence of those technical terms or the general context that a non-international armed conflict is, although I totally see your point. But what I try to do is, with targeting, I think there's actually a rule that explains to some degree who may be targeted. You start from the prohibition, and then there's an exception that says those who DPH are the exception. And you don't find that for internment. You do find notions of there will be internment and this is how it should be regulated, but you don't have the notions of how does this apply and to whom does this apply. And so I don't think there's an exact match between the two in that respect. And that leads me directly to Elvina's point on the lesser evil approach, and because that was definitely a difficult point for me, and I guess here again, I didn't want to distort IHL on the basis that my conclusion would lead to interpretations like the one you made, Elvina. And so, first of all, I should say, and that's applicable to other questions actually, but I don't think my conclusion should be understood as meaning that IHL favors one over the other, so that IHL would favor targeting over internment. And to be really clear, I think the starting point is to say there's no need to have strong permissions under IHL to start with. And so the absence of strong permissions does not mean there's a prohibition. And if you look at IHL only, I think no one cares whether there's a strong permission as long as there's no prohibition. So IHL does not require that. On IHL, like internment targeting will be pretty much the same. So that's the first point, I guess. And so my conclusion in that respect don't really change anything. I'm not expanding the categories of persons who may be targeted or restricting the category of persons who may be interned. I think if anything, my conclusion shows that the IHL of NIAC is underdeveloped and should lead us to reinforce IHL and to think about who may be interned in NIAC. So that's more a call to go in that respect. Okay, so maybe in a couple more minutes, yes, the other one that I not struggled with, but actually I would have loved to have the time, and maybe that's the next research, or if anyone is interested to work on that in the audience, I think that's an amazing question, is, as you say, Elvina, is the question of addresses. And I mentioned that in my conclusion that I focused on the question of whether permissions exist, but I could not, for reasons of space or scope of the research, look at who are the holders of those permissions. And I think, so the short answer, I guess, is I don't have the answer on who are the addresses. And, you mentioned mercenaries, or I guess you also have in my private military companies. So I thought of, I would start by saying, if I were to do that research, I would start by looking at who are the organs of the state. So for me, it's a question of attribution to the state. So, but then it does not even answer the entire question, because you can ask, well, who are the organs that usually would be granted those permissions, even within the normal organs, even within Article 4 of the draft articles on state responsibility. Do you start by saying it's those permissions can be used by the military, and that starting point would be, how is the military defined under domestic law? Whether do you go further than that and say civilian entities within the state apparatus are also entitled to enjoy those permissions? So what happens when a civilian agency is involved in operations like that? And then you open it to outside of state organs and look at de facto entities falling under Article 8 of the draft article. So I don't have the answer. What I think, if I remember correctly, what I say at some point is that IHL does constrain the type of agents who can act upon some of the strong permissions. For example, and after that, Ido, I promise I stop. If you take Article 21 of GC3 and the permission to intern prisoners of war, you can link that to the rule that POW camps must be under the direct supervision of an officer from the regular armed forces of the detaining power. So in that case, I think this constrained the application of the strong permission, and it gives a sense of what the logic of IHL is. The rules of IHL are mainly conceived to address the armed forces of the state. So that's an element that I kind of like opened in my conclusion, but I think that's a fascinating question, and I would encourage anyone to look into that. So I would love to answer the other questions, but I'll stop here, and maybe we come back to them in the Q&A. Thanks.
Perfect. Thanks, Anne. And now let's start with the question. I think Ethan Diamond has a question, and he raised his hand.
So I just began by saying thank you. It sounds like a really fascinating read, and after listening to this discussion, motivated to go and find a copy. I wanted to ask about an area of IHL that Elvina briefly alluded to, the law of occupation, and how it plays into this this analysis of the nature of IHL. So in the law of occupation, much of the law of occupation is preoccupied with the relationship between the occupying power and the population in occupied territory, if not all of it. And the law of occupation, as it's sometimes described, authorizes the occupying power to implement certain measures in lieu of the ousted sovereign of the occupied territory. So there's a relationship that's formed between the occupying power and the population of the territory, and it's a relationship in which the occupying power under IHL is in some sense permitted to enact legislation, to take all sorts of measures, including, it was mentioned, detain people under certain circumstances in the occupied territory. So I'd be interested to hear a reflection a bit about the nature of those provisions relating to the so-called authority of the occupying power, and perhaps just to sort of highlight a concern there, or at least to sort of perhaps fine-tune the question. There are some who would say that the relationship between, while IHL allows the occupying power to implement certain measures vis-a-vis the occupied population, it's a different sort of relationship than the one that the sovereign has with people under its jurisdiction. So when a sovereign creates legislation, the relationship is it has authority to create legislation, and the population subject to that legislation have a corresponding duty to abide. So if a sovereign lawfully detains someone, that person is obliged under law, it has an obligation to remain in detention. The relationship as sometimes conceived between the occupying power and the population in the occupied territory is a little different. The population of the occupied territory aren't seen by everyone as having that same sort of corresponding duty. So international law says you, the occupying power, can exert power over the population of the occupied territory. You're not committing a violation of international law by doing so, by, for example, detaining someone under certain circumstances. But the population of that territory don't owe you any allegiance. They're not subject to the same sort of corresponding duty to abide. So that's it's a sort of this kind of Hoffeldian analysis of rights. It's a bit different. So I'd be interested to get your reflections a little bit about how the law of occupation plays out in your analysis. Thanks.
Please.
Okay, thanks, Etienne, and it's very nice to see your name pop up on my screen and to see you very briefly as well on camera. Thanks for the question. So I do address the law of occupation in the book in some detail, also covering the first question on whether IHL actually authorizes occupation, which the answer, of course, is no. That's not the point. And then more related to your question, I guess I go to some extent in that. I don't know if I have the entire answer to the full question, but at least on the first part of the question, which is on the idea that IHL allows the occupying power to enact legislation. My take on that is to say that yes, actually, we usually refer to two articles, Article 43 of the Hague Regulations and Article 64 of Geneva Convention 4 as being the basis that authorizes the occupying power to legislate and to enact that legislation for the different reasons that are mentioned in those articles. And very often that's from those two articles that we speak about the rights and duties of the belligerent power, but including the notion of rights. And I think it's very interesting that we find the word right in this respect, because I guess that actually comes to answer the second part of your question as to the corollary obligation from the population. But just to come back to the first part, I argue that those two articles are actual strong permissions, because so on one side, one of them is built as an exemption from an initial prohibition, and the second one is actually an explicit strong permission, in my opinion. So I think there's no question in that respect that there is a power or a permission for the occupying power to enact legislation. The question now is on the corollary obligation for the civilian population, and whether this is the same as when the normal sovereign does that. I didn't go to that part. My initial thinking would be to say that, as I just mentioned, the fact that the term right is used in relation to that right of the occupying power is very telling, because I actually go into the detail of the definition of a right. And for me, a right is actually a higher degree of permissiveness than a normal strong permission, because a right comes with the corollary obligation for the other entity, which can be the other belligerent, but which can be someone or something else depending on the norm, to abide by the rule. So not to say that this would necessarily be my conclusion, to say that it's exactly the same between the sovereign and the occupying power, because I haven't gone into that question myself, so I don't know if I have a strong opinion at this point, but I do think that it is a good question, and maybe to inquire a bit more as to why we use the term rights specifically for this, and whether that's that corollary obligation is there, and if not, actually we should not be talking about rights. We should be maybe talking about permission, but not rights, which again for me is a different degree. So I hope that helps.
Yeah, thanks a lot.
Okay, thank you, Eitan. We actually apparently had some of the questions answered during the last couple of minutes because they were withdrawn. So I will add my question. I want to ask you, Anne, about the whole process which Justice Moroni referred to as the humanization of international law, and especially within the context of international humanitarian law. Do you think that what you refer to as strong permissions could or could not be affected from that development? And if there is a strong permission under IHL, it would not be affected, or it would affect it less strongly by the development of human rights law within international law, within public international law in general?
Thanks, Ido. So I understand your question as so the general relationship between IHL and human rights law, and whether you do you mean by talking about strong permissions, going towards the narrative that there's a humanization of IHL, or do I understand your question correctly?
I think that where you're talking about strong permission, you would say that the applicability of human rights law is less influential about IHL, and therefore IHL would remain less restrictive when you have strong permissions with regard to soft permission.
I see. Yes, that's a very good point. So I would say that articulating the notion of strong permission hopefully will resonate within human rights scholars, but also human rights mechanisms, because that hopefully allows them to use IHL a bit more, and also to understand the relationship between the two legal regimes. So I'm very much looking forward to seeing whether this, that concept is used elsewhere. I do think that putting answers to the question of whether IHL provides legal basis, which is the question that human rights mechanisms would ask, and answering that, first of all, it's there's no exact match between the notion of legal basis and that of strong permission. It's you have to go into a more granular level to understand the relationship. So first of all, I hope that this clarifies how IHL can or should be used and interpreted by human rights entities. And second, I think in the end, again, I don't think I changed IHL. I think I just I hope I helped clarify what IHL means. And in that sense, I don't think it changes either the relationship between the two legal regimes. I think we'll see from courts how they evolve. And as I was mentioning to you, Ido, just before, I haven't had the time to go through the judgments, but of course, the Georgia versus Russia number 2 judgment from last Friday or Thursday. I went directly, I delved through it and was trying to see whether, it made sense based on my answers. I was very interested to see that, the court, the European court said that basically they not declined, but I guess they said they will not. They consider that they do not have jurisdictions in cases of active hostilities. So they use the notion of states jurisdiction to say, well, that those situations do not fall under the state jurisdiction, so it's not the court's jurisdiction either. So that realm is entirely left to IHL in a way, and the European court will not touch active hostilities situations, which actually leaves, a lot of space for IHL to say, well, there are strong permissions, and this is how IHL should apply and regulate those conducts. And so yeah, maybe in short, to be seen how this notion is used by those entities. Yeah.
Okay. Thank you very much, Anne. I think that brings us to the conclusion of the event, actually right on time. And I want to thank again commentators. I want to thank Elvina and Aurel. I want to thank you, Anne, of course, for coming to this book launch with us. And I want to thank Carolina for helping us coordinate the event. And of course, all the audience. I do want you to follow ALMA on our social media, on Twitter and Facebook. The edited version of this event will be available on our YouTube channel. I put in the chat the link tree, which will provide you all the links to ALMA's social media and websites, accounts, and handles. And I do invite you to join us for the next events, on which you will find information on our website and everywhere else we're active. I think that's right about it. I do invite Anne and the commentators to stay when we finish the event after everyone left to a few concluding words. And thank you everybody for joining us, and please do join us for future events. Have a lovely evening and afternoon, depends wherever you are. Goodbye and thank you.
Thank you. Thanks, Ido. Thanks, Aurel and Elvina, Carolina. I really, really enjoyed it. And thanks everyone for attending.
Me too. And congratulations, Anne, again.